Welcome back, everyone, and I hope the tea break, although virtual, has been a relaxing one. We've had a few good sessions in the morning. We've heard the lender's perspective on the issues. We've heard an interesting litigation funder, Omni Bridgeway, on talking about what's the future, what are the next steps. We've also had a good presentation on restructuring and refinancing from SBI Capital. But this session is to address the elephant in the room, the distressed assets. We heard in the morning session that while the future looks not as bleak, if I may, there are a lot of bad experiences in the past. This has made lenders averse and more careful. They are taking risks which are limited and are worried about how they are going to recover the distressed asset sitting on their balance sheet. They pointed out the issues including slow arbitration and recovery process and the IBC not living as much as up to its promise. This year's union budget might as well be called the infrastructure budget, given the heavy focus on the sectors to pull us out of the current recession. This time, the government has allocated 34.5% more than last year to infrastructure development. 20,000 crores to set up and capitalize the Development Financial Institution, or the DFI, to act as a provider, enabler, and catalyst for financing infrastructure. Almost 1,18,101 crores have been allocated for the Ministry of Road and Transport, of which 1,08,230 crores is for capital expenditure. Under the Bharatmala Prayojana, with an estimated investment of 5.35 lakh crore, already 13,000 kilometers of roads worth 3.3 lakh crores have been awarded for construction. Large amount of money has been earmarked for ongoing and new economic corridors, expressways, and rupees 1,10,055 crores have been allocated to railways. So there's overall deployment in both the roads, railway sectors, and infrastructure in general. However, deploying this kind of capital in infra assets is a tall order, and the success lies in effective implementation, turnaround times, and monitoring. More importantly, if anything goes wrong, in the recovery. Infrastructure assets have been stressed even before the pandemic arrived. In the pre-COVID economic slowdown, despite such exuberant display by the government in funding infrastructure, we saw infrastructure projects fail to materialize. In 2018, despite this spending, India fell 9 places since 2016 to rank 44 in Logistics Performance Index, a measure through which the World Bank ranks countries based on their logistic performance. Infrastructure is one of the 6 parameters for this index. Since COVID-19 disruption, the share of infrastructure finance companies in infrastructure outstanding credit has increased to 53% as of September 2020 from about 38% 5 years ago. There has been a lot of to and fro on whether RBI measures like partial credit enhancement scheme have been useful in softening this blow. According to official data, 63% of more than 21,000 cases pending in NCLT benches as of January are insolvency and IBC cases. This surge in insolvency cases has to be met with robust judicial infrastructure and long-awaited introduction of cross-border insolvency regime and pre-pacts for larger companies than MSME. It is expected such changes would streamline and improve the efficacy of the IBC. The effective recovery under the IBC, despite all the gung-ho about the regime, is just 24%. This is mainly due to the complex assets in infrastructure-related sectors which have been difficult to resolve, and a large part of it is also attributed to the lack of experience in the players involved in this segment. The need of the hour is to shift focus from restructuring to recovery and from domestic recovery to international recovery. While India is 136th in contract enforcement, it leaves footprints globally. And today, Indian borrowers or debtors, if I may, have a lot of recovery possibility overseas. Litigation finance and management can play a game changer of role to supply money and manpower to support these large recoveries. It is in this background that I am joined by four eminent speakers to discuss the future of distressed asset. Let me start by introducing my panelists. Rahul Chaparwala, Executive Director, Special Situation Funds, Kotak Investment Advisor. Badrinath Durvasula, Managing Director, Legal, SR Group. Marijn Flinterman, Head of MENA Distressed Asset Recovery Program, Omni Bridgeway. And Mr. Sanjeev Pandey, Deputy General Manager, Stressed Asset Recovery Group, SBI. I welcome all of you all for this exciting panel, and I want to start straight in diving with my first question to Mr. Pandey. Mr. Pandey, SBI has the largest exposure in the country on infrastructure assets. And hence, I want to hear from you of what's the current scenario with regards to stressed infrastructure assets in India.
Yeah, actually, a very large portion of our NPA assets come from the infrastructure sector, almost running into 30 to 35% of my portfolio. And we have been trying to sort it out through various means. And mainly these companies from infra lie in the power sector, EPC, construction, the roads, and some from real estate. Although we don't have too much of real estate, but these three sectors are the big ones: power, EPC, and roads. The toughest sector to find a resolution now is power, because this is mostly thermal power, which has got so many issues like the environmental issues now, sourcing of coal, getting PPA. So it has been difficult, and wherever we have found a resolution, the recovery has been not to the expectation. Although government has tried to chip in, they have pushed the government agency like NTPC, the Power Finance Government to push and buy out some of these assets, but not many transactions have been successful. We have tried IBC, but IBC we have found it not very effective in especially infrastructure sector, because infrastructure resolution required some slightly longer period of time. It's not that you can finish this resolution in 6 months or 9 months. So that has been one of the issues. And we have also tried the RBI resolution framework, the ICA framework. There also success stories are there, but few, not many. Then road sector also, even under IBC, some places we have not found many buyers, even on the running roads where the toll is being recovered. So maybe it is a matter of impact of COVID, because of which the traffic went down. So there was not much interest. So EPC is another sector where, because of the low, very small asset base of these companies, the banks and the lenders have booked large losses. And most of these EPC companies have not found much of a resolution. Again, because of lack of interest from investors and the BGs. A lot of BGs were given to these companies, which are getting involved because the projects were not completed. So what we are looking at a resolution here is that IBC may not be a right fit, or maybe what we can do is that create some kind of SPV where to transfer this asset and try to complete the project. That has been one model we have been trying, and some success we have found in few cases. But it is a challenging sector, so this is challenging to resolve infra sector. Yeah.
So if I may summarize, the main challenge today is resolution, and that's the current scenario, irrespective of fresh capital coming in. Sectors like power, EPC, they remain very challenging to resolve, especially because the recoveries and the environmental clearances, etc. And Rahul, of course, you are part of a special situation fund, and your focus is primarily distressed asset. What do you say? Do you resonate with what Pandyaji says on this? Do you have a different experience?
Hi, hello everyone, Rahul here. Uh, am I audible?
Yes, you are.
Yeah, fair. So, now, I mean, how dare someone disagree with what is coming from SBI, right? So, yeah, I pretty much agree with him in the sense that, it's a little tougher sector. It's a sector where you cannot probably change the management and, try to take over control and run it on your own, especially when it comes to EPC and stuff like that. Uh, but again, within infra, if you see, I mean, infra is one very wide sector. There is power. Within power, there is renewable, the new infra, so to say. That's the way I prefer to call them. And old infra, old power in the sense, the thermal. Thermals have been having their own set of challenges, apart from the fact that, there have been coal linkages issue, or certain places, the PPAs have not been honored, or there are some issues in the PPA. Okay, they have not been in favor because of preference to the green energy. Obviously, this year we saw some bit of positivity for thermal sector, because the power sector demand per se, the power demand per se has gone up, and there is some hope for the thermal power projects as well. But I guess the challenge out here remains, if there is no PPA in place, or PPA has been has been discontinued, or if coal linkage is a challenge, then you're always going to be having a challenge in resolution of the core thermal power projects. EPC, I fully agree with what Sanjeev said. It's a different ballgame altogether. To keep the machinery cranking, you require the required performance guarantees, BGs, and stuff like that. And once the account turns NPA, these things are not coming, and in a way, it kind of doesn't let the cycle going. And here is the case. Probably there is a lot of scope, a lot of litigation. Lot of stuff is pending on litigation front. So that's why there are challenges out there. Yes, roads also have seen some bit of challenge. Not denying that bit, because of slowdown which we saw generally in last 2-3 years. But probably there's less of an impact. I mean, more impact within the infra, the sector which is borne the maximum brunt is basically the thermal bit of it on the power front. So it's been a little sad situation. But at certain places, we've seen certain resolutions happening, especially in non-thermal power sector. Let's hope overall, there is and this will require a lot of push from all quarters. The concessioning authority will have to be supporting, the PPAs will have to be honored, some bit of stuff will have to be done on priority for getting the linkages in place. If all that falls in place, hopefully there will be more positive sentiments around the resolution.
No, those are important points, and PPA has been a biggest concern in the power segment, and India is not the only country where you're seeing PPAs being changed or withdrawn, and internationally, at least in Eastern Europe, we've seen a flurry of litigation, investment arbitrations, if I may, against Spain and now against Ukraine, which are coming in just for this. That the government has promised a PPA. There's a lot of foreign investment and lending which has happened to construct that power plant. Now is the time to get the revenue, and there is a change of government, a change of heart, which is leading to renegotiations. And I think what we are seeing is a lot of shift to recover that money, or to make the government honor the contract by saying, sorry, you need to be good for your promises, or pay damages to us. And I think that's the trend in the future for the Indian market. But I'll park that issue to the side for now, and shift focus on the corporate perspective. We've heard from the funders and the lenders, but what I want to know is from the corporate, and Badrinath, you of course are part of a thriving group who've seen very closely the last era of stressed asset and infra, and then faced COVID-19. What do you think has been the impact of COVID-19 on assets which were already stressed?
Yeah, this is Badrinath, representing, I'm coming from the SR group. But at the same time, the views which are expressed are generic in nature, nothing related to the company as such. That's a kind of a disclaimer on which I would like to start this presentation or a little conversation. I think the infrastructure has been going through a kind of a tough scenario for over a decade now, whatever may be the reasons, whether it is a lack of government support or the institutional support or the kind of a difficulties which one has faced. I think those have been all in existence all through this last decade as such. So the performance is not really good on the infrastructure front, be it in the power sector or any other sector, roads and buildings or any other construction. But the point I would like to state here is that the COVID has really compounded the kind of a problems we used to have it. In the sense, earlier there used to be some kind of a chain of mechanism that used to run the show modestly or somewhat on the lower front. But today, the COVID for the last couple of years has hit us very badly. Every industry, the infrastructure industry, very badly in terms of its performance. I think if you look at the other industries vis-a-vis the infrastructure industry runs on a model of the contracting to subcontracting to subcontracting. There is a chain of people who are associated with the kind of infrastructure industry. Unlike some other industries, I'm not really exempting some, but I'm putting focus on the infrastructure as such. So here, the receipt of the sums in one hand or the non-receipt of the sums in somebody's hand is the one which is going to cascade down the lane to the last of the subcontractor who has been working on the project. So the projects being far and many, the COVID impact hitting the principal contractor has really transcended to the every contractor on the turf. As a result, the assets which are not only of the principal contractor, but even of the subcontractors and the minor subcontractors, even everybody's asset has been put on the kind of a threshold. It's a kind of a real scare. It's a kind of a non-performance. It's a question of non-existence within the domain as such. I think this is a kind of a great scare which have been put. But having said that, there are some principals, the owners, who have been supportive of the cause and have been extending some kind of a concession, but they are minuscule in nature. If you look at the percentile part, it's about 20% of the owners or principals who have supported the contractor's purpose. So as a result, the kind of a problem more or less is hanging the way in which it was hanging. And given that kind of a scenario, today, if one is into either IBC with its ambit wide open with the amendment that has come in 2018, etc., I think that things look very steep and things look very difficult at the point of time. The second dimension to the problem is the institutional financing. We just now heard the SBI view. The kind of an institutional financing has become far more stricter than what it is. So even if you have to lend, you have to take on loan and then run the show. That is not happening at this point of time, which was not the case earlier prior to the pandemic. In the pandemic, the institutions, rightly or otherwise, have become more sensitive. They look at the companies, they go for very selective lending, they go for a higher charge on the assets, and all these things compounding, the infrastructure industry is really struggling at this point of time. So we are only hoping that coming out of the woods, now probably in the next fourth quarters could be slightly reasonable and optimistic, and we may slightly get over these issues, and we can deliberate further on the difficulties which we have.
Those are very relevant points, Badrinath, you make. And I would point out in the last session, the lenders resonated this sentiment, and they said there is a shift to more governance and a good crop, and they are ready to move into more secured projects like HAM, or where there's a private equity running the governance, but they are pretty much averse to projects where there is BOT, or there is a toll operator kind of a project, or where the promoter is fully entrenched, where there is governance issues. So I think the sentiment you resonate is pretty much aligned to what we heard in the previous session by the lenders. But they do give a ray of hope in the sense that if the governance increases and the crop is good, the lenders are pretty much ready to invest. And if others take risk with them, like private equity or special situation funds, I think it gives them more confidence to invest, especially keeping in mind the past experiences. But on that note, I want to ask the same question to Rahul. And Rahul, do you share the sentiment which Badrinath shares, or would you like to add something more to the impact of COVID-19 on stressed assets?
So, again, COVID-19 has had infra is a very broad definition, as I said earlier. You have roads, ports, power, telecom, hotels, EPC, everything. So obviously it has had a different impact within subsectors. Certain sectors obviously have brunt a significant, borne the significant brunt of it. You talk about roads, especially the toll road collection. Yes, they bore quite a lot of brunt of it. First cycle, initial lockdown, the collections have dropped significantly. Second cycle, again they drop. In fact, we happen to have one road project in our portfolio, and we saw that. I mean, this is something which I've been evaluating for last 18 months, 24 months, and we pretty much saw how the toll collection is panned out and how is going to be the impact on the valuation. You talk about, hotels is not a conventional infra sector, but yes, it is part of the RBI definition. These guys have bled like crazy, right? The ARRs have dropped like crazy. Don't expect the ARRs to pan out to come up at least for next couple of years to pre-COVID levels. Occupancy level has dropped significantly. Has there been similar impact on the ports or all the ancillary stuff? Answer is to quite an extent no, but for the first the first lockdown. In fact, those into containers and other ancillary stuff, they are seeing best of the times for themselves. So to that extent, it's not been bad for them. Power, I would say, again, as we said, thermal is nothing got to do with COVID. It has its own set of problems. If anything, the green energy is seeing great buoyancy. So it's a mixed impact. Certain sectors, which were kind of consumer facing, so to say, direct consumer facing, they have borne significant brunt of it. In certain places, there is a need to have a significant haircut, either for the equity holder or for the debt lenders. I mean, whosoever you look at it. But there is a need to have a significant haircut. And probably once we see, the morat which was given from, recognizing incremental NPAs or referring to incremental IBCs, once, now is the time we'll see a real pain to pan out. And probably here is when you'll see the NPA numbers, especially infra NPAs, NPA numbers will start increasing. And my presumption would be this will be not pan infra, certain sectors which I spoke about will see a sharp rise in the NPAs. And probably there will be serious work needed around it to see resolution happening. So it's going to be a mixed bag scenario, so to say, for infra of COVID, is my take.
Thanks, Rahul. And I hear what you say. NPAs are going to rise. The shutter is closed right now, but it's going to be open. And once that happens, we're going to see a lot more NPAs. That means we're going to see a lot more resolution inside or outside the IBC process or otherwise. And that's why I want to ask this question to Pandeyji. And he's of course been in the forefront of the IBC regulation coming in India. He was part of the drafting committee of the IBC and now part of the IBC2 suggestions. And I want to ask you, sir, what has been your experience of resolution through the IBC in the past few months?
Yeah, IBC actually, as we all know, IBC was suspended for almost a period of 1 year. And that has led to somewhat loss of momentum. So IBC picked up momentum after that SR still judgment. But when it was suspended last year, and then of course due to COVID, most of the benches were not able to function. They stopped taking routine matters and only very, very urgent matters were being heard. Even starting online hearing also took some time. So it has been a setback to the IBC process, of course, I accept that. And besides the COVID impact, there has also been multiple issues. NCLT members have retired actually. So now the current strength, as per my knowledge, is only 29 against in 25 odd benches. Only 29 members are there. Many of the benches are being run part-time from some other member coming from a different town. So that is leading to not very efficient functioning. Even Supreme Court recently gave direction to the government to immediately nominate people to the tribunals. So we hope that soon we may have full bench strength in the NCLT so that at least COVID impact can be overcome. That's my input.
So, sir, with this impact, is the focus shifting to non-NCLT resolution methods? What's your experience in that in the past few months?
Not exactly. Actually, and now earlier the banks were very bullish on the NCLT process, but now we are weighing, because one thing which has come as an impact of COVID is that the valuation of assets has gone down. And my sense is the impact on assets is somewhere from 10 to 30% in different sectors. So that has led to less number of resolutions, one. And wherever resolutions were happening, even some of the resolution applicants who have already submitted their plans, they are backing out because of the decline in valuation. And going forward, we are, whatever resolution plans are coming, we are looking at plans very close to the liquidation value, as many of you have seen in the case of Videocon and even that Siva Industries and all that. So that is one impact of COVID, that we are looking at lower valuation. So banks are now having a double think that whether should we go for some kind of OTS decline, which is much better than what we expect to get in a resolution plan. So that is one option on the table. And after like 4 years of IC, many of the borrowers also, they are coming forward with a good OTS proposal. So now the banks have multiple options actually. We can do a compromise. We can do a ICA kind of arrangement. Then IBC is one of the options, which has actually become the major option in the last 4 or 5 years. But now because of this slowdown, slightly there is a double thing. Hope that the government will take care of this soon, so that again that confidence in the IBC is rebuilt. And of course, we are also looking at other RBI scheme for MSMEs. So now with PREPAG and RBI scheme, there is a competition. So we have option of going for either. So these kind of things are there. But main impact is the capacity of the NCLs. Unless we build the capacity, we cannot build further confidence in IT. That is my opinion.
Thank you, sir. And Badrinath, I want to come to you because there was a mention of SR Steel. Of course, I know your views are personal, but we would like to hear from your experience on the other side. Do you face the same experience of what we heard from SBI? Has COVID-19 played a dampener on the IBC and non-IBC experience of resolution?
I think it's a very valid question in the sense there is a totally structural shift than what it used to be prior to that of the COVID. What used to happen is there was an utmost seriousness in terms of the IBC and its application. And there were people committed on both sides, both the institutions as well as the corporate debtors. They were also very keen to see that these processes run. But today that has been bogged down by certain other things post-COVID. As rightly pointed out just now, the valuations have taken a real good beating. Whatever be the kind of a quality of the asset, the valuation today has been almost about 30 to 40% discounted, or in some cases, it's much more than that. So I think that's not really helping the kind of an institutions to recover the kind of a sums going into IBC. So that's one major statement. Second, the very procedural aspects of the IBC themselves are a kind of dampeners in terms of moving ahead with the IBC at this point of time to see that whatever best is recovered is recovered. Now, onto the non-IBC kind of a thing or non-NCLT kind of a thing, there is an increased shift on the part of the institutions to negotiate with the corporate debtors in terms of one-time settlements, or we call it as a kind of a OTS. I think that's been on the rise. That's been on the rise. You name the institution today, I think they're all ready for it. The OTS are something which is like a certainty which is there on the table as against the IBC, which could have been really the light of hope. I think that's a market shift in the current thinking of the kind of an IBC working part of it. So I think OTS is beneficial in both ways, that the institutions are protected to a certain threshold, as much as the corporate debtor is also protected, that if he commits to certain phases of payments and certain levels of payment that is being done. This is not the only thing. Let me also illustrate one more experience. OTS comes with a deadline. Even those deadlines to pay, let us say by 31st March 2021, if the OTS ends, the institutions have got willingness to extend the kind of a deadline by at least another 6 months to 9 months to 1 year depending on the case and depending on the clientele. It's not generic, but that is something which everybody understood, that instead of playing into the hands of the IBC and look for an uncertain future, let there be a kind of a relationship with the kind of client directly and have some kind of a realization. I think that's a market shift which I'm seeing in the situation. So today, the enthusiasm to go into IBC has a bit waned. Maybe it will come back, and hopefully should come back, because there is a robust statute and the judgment supportive of it in place. But the point is that today, the Indian commercial institutions have also got a sense of recognition that what they need to realize is what they should realize. I think with that practical wisdom, there is a market shift from the IBC to non-IBC kind of a settlements, and deferring the timelines and giving a long rope. That's a very positive sign, which is required for the Indian kind of an entrepreneurs, as well as the kind of a supportive methods which have to be in place to ensure that the industry comes through rough weathers.
Thanks for those views. And what I hear is it's not only COVID, but there are issues and challenges per se with the IBC regime. Sanjeev ji pointed out that one of the biggest challenges is the benches are empty. There are issues with procedure, and I think I hear the same thing from you, Badrinath, that the experience has been okay so far, and IBC, of course, has been completely dismantled in a sense during COVID, so people are moving out. And when we talk about moving out, the new kid on the block is the pre-pack deal, which is a hybrid, some sort of between the OTS and the resolution process. Now, of course, we have that in the MSME with a very small ticket size. I'll come to that later. But I want to talk to Rahul on this, whose team have interestingly been doing deals structured like a pre-pack, almost following that mechanism. And I want to understand from you, Rahul, what's the role of pre-pack in this distress scenario, and what's your experience so far?
Thanks, Prateek. I don't think anybody would have a disagreement with the time frame involved in resolution of situations under IBC. I think it's a phenomenal regulatory framework, just that time frame has been a little longer. Our fund has actually acquired an asset under IBC framework. At the same time, we continue to explore situations all across distress. And within that, our experience with pre-packs, while we don't have pre-packs in a regulatory framework as yet in India, but for a recent one for the small borrowers. But largely, what is pre-pack? It's basically a OT settlement with the borrower being in control. Also, the asset has not been performing that well. There are no intention issues with the or integrity issues with the primary borrower. So. And then it becomes more of a bilateral arrangement where it's not fraught with all those regulatory challenges, interpretation issues, someone coming and litigating and stuff like that, right? So to that extent, I think pre-packs could be a go-to route for resolution of stressed assets, and probably the efficacy of efforts to rewards in the sense resolution could potentially be much higher. We have seen that happening for our fund in a road asset which we acquired, and we are running that road asset along with the promoter, the primary borrowers, and I think it was a very smooth settlement process. We have seen shades of that panning out in a couple of more deals where we kind of funded a particular asset, we infused equity, and lenders got an exit. So which again, you can say it's kind of a pre-pack. Now, if we see actually pre-packs come into play for larger set of borrowers, I think it will add further strength to the overall scenario. The investors like us will get far more comfort, because then it gets a regulatory stamp, it comes with several other regulatory dispensations, and it kind of, you can start a fresh kind of a scenario. So we are very hopeful that the resolution of stressed asset, and especially infra could play a significant, could see a significant uptick if prepacks come into play, and we would be very keen to participate in that. That's my submission on it.
Right, sir. And so from SBI's point of view, from your point of view, what do you think pre-pack deal can play a role in distress?
Yeah, thanks, Pradeep. Actually, SBI is the first bank which has come out with a policy on pre-pack, and we are very, very bullish on this mode, although we have only few transactions which are coming up. Only challenge here is that one pre-pack is only applicable to MSME as of now. So only I have a sense that transaction with exposure up to say 50-60 crore only may be covered. And second challenge is that these kind of companies, even under IBC, CRP also, have not found much interest. So the advantage with pre-pack is that the promoter continues to be in the control of the company, and the RP has a only supervisory role. Second advantage is that most of the job of preparing a plan or IM, whatever is done before the application is filed in NCL. So a lot of time is saved there. Third advantage is that the liquidation can be avoided, because that has been one of the biggest risks while going in CRP, that 80% of the cases land into liquidation under CRP. That has been our experience in last 3-4 years. So now under pre-pack, at least we have one base plan on the table. So when the promoter is in the control, and it is a worldwide phenomena that most of the resolution happen under the control of the existing promoter, because they know the CD in and out, they know the corporate debt, they know the company. So that is the advantage. They start with the advantage. Second advantage I'll say is that there is not a big public announcement of insolvency. It is a kind of a silent announcement where the market at large doesn't know that this company is undergoing pre-pack. So that doesn't affect the credit flow to this company. The employees don't run away. Those are the impacts of CRP announcement we have seen. So those kind of impacts on the valuation of this company are taken care of by pre-pack. Only problem I see is that it is not yet been launched for the general companies, like other than MSMEs. Then I think real test of pre-pack will come when it is promulgated for all the corporates. Otherwise, it's a very good framework. I am very bullish, and because most of the job is to be done before the filing, I see that earliest filing will happen somewhere around December or November, not before that. Because right now, whenever it is being applied, the formation or the preparation is being going on. So that is my sense. Thank you.
Thank you, sir. And it's good to hear that SBI is bullish on pre-pack, and I think that is one way to go ahead. But I do hear the concern of the control lying with the promoter. And on that note, I want to bring a very relevant topic in for you again, sir. The Lalit Kumar Jain experience and the Anil Ambani experience has created a new outlook towards personal guarantee recovery. We are now hearing a lot of banks, a lot of lenders focusing on personal guarantee recoveries. What has been the change in outlook in your team for personal guarantee recoveries?
Yeah, very good question. Actually, very, very relevant at this time. So after this judgment in that Lalit Kumar Jain, because we were filing the matters under this individual insolvency, because this law was promulgated sometime in 2019 December for the individual insolvency. But since it was stayed by the court, some High Court, and then Supreme Court took cognizance and concentrated all the matters under their control. So this judgment has come out as a big relief, and most of the banks are filing cases now. We have already filed more than 1,000 cases of personal insolvency in NCLT. There are some basic challenges coming from that how to trace the asset held by the guarantor. Because earlier also we were having some collateral security, and we were enforcing those collaterals through the SARFAESI route and even going through the OTS, which is somewhere close to the value of the security. So that was the norm among the banks. But now we are looking at something extra, over and above what is available as a collateral, because under this law we can get access to non-encumbered, unencumbered assets also, and even encumbered assets wherever some surplus value is there. So that is now becoming a challenge, although banks have been trying to use these detective agencies, asset tracing companies, but it will be only future will tell how far we succeed, because of course we are taking these assets to the court. Only I think few processes have started as yet where actually the COCs have happened. So I am not very sure what will come out of this. We are going with multiple assets to the court. How much the RPs will be able to take recover out of them, that is something a question of time, only time.
Thank you, sir. And I'm going to quickly take the last question in this session, in this segment, and move to Merain, who's patiently waiting for his role of questions. But Badrinath, just quickly, if you can say, how do promoters react to this from the corporate side? Because you've heard SBI; they're pretty much gunning for the promoters now. Are they uncomfortable? What are they thinking now?
No,
So
there
there is
has
sense.
been,
Yeah,
is
sorry.
is it for me, Pradeep?
No, this is for Badrinath.
Okay, sorry.
Yeah, Badrinath here. I think this is a very valid question, and post this judgment, and even prior to the judgment, when the judgment was going on, people have been very sensitized, and I would look at the top 100 corporate houses and the promoters thereof, who have all issued without any kind of an exception a guarantee to run their businesses. That's a kind of a norm those days. It was happening, and during the period of the last couple of years, when this issue has come up on the table, I think there is a bit of a cleaning up which has happened to the best of my knowledge. The cleaning in the sense that wherever the personal guarantee can really hit, there is some kind of a hedging that has been taken place, and things have been real spruced up in the last couple of years. There was a window available for most of them to really do a kind of a little dressing that's required to be done. As a genuine, I mean, if I'm an individual, I would do the same thing, and no corporate promoter is different than that. At the end of the day, he's an individual. They have done that. But having said that, this judgment has come like a kind of a watershed. It's a good in terms of like a fundamental right, that we all have the fundamental rights. But how much of it can be really be exercised? This judgment is similar to that. Yes, there is a fundamental right, but how much of it can be really be devolving, and how much of it can really be recovered about it? I think it's a kind of a challenge for two reasons. One, the basic relationship the institutions and the promoters have over a number of centuries, or maybe a kind of decades. They have the kind of a wonderful relationship. If you look at the top 100 corporate houses and top 30-40 funding houses, they are always like a friends, giving, borrowing, taking, paying back, etc. It's a kind of relationship which has been there for a long time. And this kind of a little fabric, it's a very sensitive fabric, cannot be torn just because one judgment has come. I think that's a kind of a mindset the promoters as well as the institutions have at the back of their mind. That's number one. Number two, if they really go after this kind of the impact of the judgment and the recovery of the personal guarantee, I think there are many things which are going to hit, and there is more an uncertainty which is in place. It's a time versus recovery. I think this is something which may not play ball to the kind of an advantage of either of the parties. I think that's where it has taken a backseat. Today, the promoters are very much alive to the kind of situation they're likely to face, so much as the institutions are also aware about it. So it's a kind of a little soft pedaling which is happening on the front. I wouldn't say that there is any kind of a concentric view for the institutions who run after these personal guarantees. But nonetheless, yes, it is yet another tool which is available in the hands of the institutions. I don't think, with all the prudence, the institutions may not be using up to the hilt. Maybe in some exceptional situations, and where the recovery rate has to be very high, or where they are under the public criticism, things can happen, but not in the case of all and every kind of a situation that is. That's a kind of a reading which we have from a promoter's perspective.
Thank you so much, Badrinath. And Merain, now coming to you, of course, you've been patiently hearing that the complaints are with the system. The system is slow, recovery is delayed because of the system. But at the same time, as you know, India has internationalized. The borrowers today have receivables overseas, they have borrowing overseas, which is, the cash is sitting outside India, or there are promoters who are pretty much owning assets in overseas jurisdictions, maybe directly or indirectly, or in the famous shell companies in several offshore jurisdictions. Now, lenders, of course, find it very difficult, as Sanjeev ji said, to trace all this, to recover all this. There is lack of experience. There is no branch offices in these jurisdictions like Cayman Island and BVI. How can banks rely on your expertise to ensure the recovery expedites and increases, especially these overseas assets which are lying across the globe?
Now, thanks, Pratik, and thanks all for being here today. It's a bit of the fate of the last one on the line to be sort of cramming for time, so I'll try to answer it quickly. But I do think it's good to talk a little bit about what is actually litigation funding or litigation finance, because I know that not everyone might have joined the previous session where my colleague Arvind was present. So litigation finance, at its very core, I would say, is a risk management tool. It's a way for claimants that are involved in litigious situations to involve external funding, but also expertise, and we'll get to that. And in the end, of course, the end goal is to solve their conflicts and getting paid. I think this is something that is often forgotten, that you may get an award or judgment, but it does not necessarily mean you are getting paid. Looking at sort of the model of litigation funders like Omni Bridgeway, so what do we do? Well, I think the core business is to provide funding. So we provide funding to cover legal fees and legal expenses in relation to the litigation or arbitration. And this is typically, I would say, almost exclusively done on a non-recourse basis. So we work on a success fee, which means that we put skin in the game and we only share in the proceeds if there is an actual recovery. Having said that, we at Omni Bridgeway would also consider non-recourse advance payments. So that would be an early monetization possibility for claimants. So in the various litigation or arbitration, what we see there, and especially when it comes to infrastructure, there are many different types of claimants. I mean, obvious ones are banks and infrastructure or construction companies, but we also have subcontractors. We've talked about that before. But also, what we see is sort of insolvency administrators or liquidators using litigation funding, and they all have their own reasons to do so. We'll get to that hopefully in a little bit. What I do think is important to differentiate is how we as funders sort of look at the stages of litigation. We first distinguish the merit stage, which is effectively the question, who is right, and what's the total damage. And then the second stage is the enforcement stage. So you have your judgment, you have your award, but then how do you monetize it? And the merit stage is typically fought out in the courts or tribunals that have been agreed in the contracts. So it can be Indian law with Indian courts, it can be English law with ICC arbitration, you name it. But enforcement typically follows the assets, and this is a popular misconception that you're not bound to the originally agreed jurisdiction or applicable law. So we look at it, we peel back the onion sort of backwards. We look at where the assets, and then we sort of try to come up with strategies to have the initial judgment or award sort of move all the way towards the assets. And I think this also explains how we see ourselves as funders. At Omni Bridgeway, we are very hands-on, so we are always involved in the stages of the enforcement, and we have a lot of expertise to do so. Some funders are a bit more hands-off, and they would only provide funding, and then it would really only be a risk management tool. It's a very much a growing industry, and it's incredibly global. I mean, we have over the last 4 decades been involved in litigation, well, in any event across the globe, I think there are only like a handful of countries that we have not been involved in, just to show how much of a globalized business this has become. Then to get to the question, sorry, this was a bit of a long intro, but I think it is helpful and necessary to paint sort of the landscape. So how can litigation funding help with overseas recovery? Well, I think the obvious example would be that funders could provide non-recourse funding of legal fees, which I think we all know tend to increase rapidly when crossing borders, and they also tend to become much less predictable. And the second one is that claimants will be insourcing specific enforcement expertise. And here also, especially cross-border, at least if you're a hands-on funder, this is invaluable expertise, which typically is supplemental to the law firms. We at Omni Bridgeway at least have been doing this enforcement on a global basis for 40 years, and we know sort of how to move litigation across borders, how to take it to assets. And I think this is a skill which is rare, and banks can tap into on a, well, as I said, on a non-recourse basis. I think it is actually a very complementary solution for players sort of in the market, so banks, claimants, companies, what have you. Now, on overseas recovery, so what we often see is that claimants enthusiastically start litigation, and they also start enforcement, but typically, and yeah, for reasons I think that we can only guess at, it focuses on domestic assets. So claimants tend to stick to their home turf. It might have something to do with sort of venturing into the unknown, not having certainty on cost, etc., etc. But the problem there, and particularly already described it, I mean, we live in a globalized economy. Assets don't stop at borders, so you cannot stop at your home borders yourself if you're pursuing assets. So we have our in-house estimation team. I mean, I think a very big difference to a lot of financial institutions is that when we are involved, we track it 24/7. So it becomes much more of a movie than a snapshot. Because in our experience, assets also tend to move. I mean, it's never a static picture. You have to know where things are moving, what would be a good time sort of to attach assets to create leverage. And as Omni Bridgeway, we've been working on more than 100 asset classes. I mean, obvious ones are bank accounts, real estate. You can also think about ships, airplanes, as Pratik said, receivables, recurring monetary flows, high-profile assets, which would have sort of attention value, which would create leverage for creditors. So when a funder gets involved, I mean, I'm now talking about sort of our experience. Now, we typically set up a detailed strategy to take the judgment or award to the country where we've identified assets, or countries, because quite often it's multiple countries, and the goal is to take the respondent or the debtor out of their comfort zone. So we do that by attaching assets and forcing them to the table. I think a very good example, and I think then hopefully I've answered your question, Pratik. A few years ago, we were asked to pursue a debtor, which was a construction company, but for some strange reason, they also had dealings growing roses in Africa. And we found out, and we waited for an opportune moment, which was a few days before Valentine's Day, to attach their entire supply of roses, which of course created enormous leverage for the creditor and pushing them to the table. So in the end, this was settled satisfactorily, which is not surprisingly how many of the cases we get involved in end up, so in settlement.
Thanks,
I hope that answers your question, Pratik.
Yes, absolutely, and thanks so much. I think you make a lot of valid points, and just for the benefit of the audience, at least in our experience, the approach is pretty much sophisticated. The investment analysts change to lawyers who can predict and portray what's going to happen in the future, and then there is the investment committee of their team which looks at it and invests. in the case and manages the recovery later on. Of course, we've seen quite a lot of this and worked very, very closely with Omni Bridgeway and other funds in giving these cross-border strategies, thinking out of the box and finding recoveries, especially for banks. And a lot of them we see are benefiting from it. But Brian, I want to ask you the same question for even the infrastructure companies themselves, because a lot of times the infra companies are not diverted or fraud accounts. They're not assets which are not paid because money has been siphoned off by the promoters, which are going to be seized overseas, or there is international default which can be recovered. Often they have claims themselves. Those claims are not paid, and because those claims are not paid, they cannot pay the lenders back. Now, the catch-22 here is to recover the loan, to recover your claim, you need money which you don't have, and since lenders already have declared you to be NPA, they cannot give you more money to recover the claim. Now, how can infrastructure companies benefit from litigation finance, from your services?
Well, I hope I understood your question correctly, Pratik, because the example you gave is sort of where companies rely on a sort of a long chain, of subcontractors, or where a default somewhere down the line causes havoc all sort of across the chain. So we often get asked by banks, sort of not just to look at their non-performing loans, but also to look at companies that they have in their distressed portfolios, because they tend to have, let's say, litigious assets on their balance sheet, which can be monetized. So involving litigation funder can have sort of a dual benefit. It can either, if there's a way sort of to monetize quickly by having an advance payment or sort of a sale of a claim, that can lead to quick monetization. And other than that, you're, as I said before, insourcing expertise. So that is one element. I think when you're talking about specifically about infrastructure companies using litigation finance, I mean, it's a bit of a different question, because in our experience, the infrastructure companies tend to be different from banks, at least when seen from a litigation funding perspective. And that's because the debtors or the respondents for infrastructure companies are often sovereign or semi-sovereign entities, and that creates a completely different dynamic, which means that conflicts are often put out in arbitral tribunals and not in courts. And of course, enforcing and recovering from sovereigns is completely different than it would be from companies, sponsors, or individuals. Having said that, it's definitely an interesting element. I mean, we at Omni Bridgeway have been doing this ever since the beginning. That's actually how we started out in the litigation funding business. And we've been enforcing and recovering from sovereigns, in the most far-flung corners of the world. And by doing that, and I think that's taking it back to what I said before, I think the key for us is always to take the defendant, in this case a sovereign, out of their home turf. Because also sovereigns, and I think we're all well aware of that, tend to have assets overseas. I mean, there may be money flows. If there are sort of commodity-rich countries, flows of commodities overseas, embassies, you name it. So there are many ways to recover money from sovereigns. I do think, and I'm mindful of time, so I do want to give a few pointers, which I think are important. And this is also Pratik for your practice. I mean, you are the expert in this. What we see often is make sure to have an immunity waiver in your documentation when you're dealing with sovereigns. Because without an immunity waiver, recovery or enforcement would still be possible, but it would be a whole lot more complex and also more expensive. So that's just some practical advice. I don't know if I have fully answered your question, Pratik, but again, I'm also mindful of time.
No, I think you have, and I think you make very interesting points. I think today people in the audience have read what happened in Kane, how they internationalize recovery by freezing assets of India in France and US. And we saw
I'll give you one last example, Pratik. That's so not recently we were sort of helping a construction company who had been doing work in Africa, in a country down there, and the bills were not being paid, and that obviously ended up in a conflict, and we got involved at some point. The way this was eventually dealt with was by attaching airplanes, which were effectively property of the government, sort of in a third country, again creating leverage for a settlement. So this is just an indication of how we tend to look at this. So you basically you broaden the playing board.
Oh, those are great examples, and I said, that the audience today has seen this in Kane, and I think you're right. The biggest misconception today is the understanding of an arbitration award. Just for the benefit of the audience, an arbitration award is enforceable in the same way Kane's award is in 160 plus countries. It doesn't matter if it's given in India or given in Singapore or given in London, because as Narayan said, enforcement works upon where the assets are. And it is on this basis I ask myself that why would not one look at Indian recovery, especially with bodies which are quasi-government, which are authorities, which are part of the government, and to ask the government to pay for their liabilities. There's a lot of recovery possible if we use the right approach. But before we close, last question, I know we're ending time, and Brian, I told you I'm going to ask you this. You are the head of the distress asset recovery program in MENA. I'm sure you work with umpteen number of players in the field. Audience would like to know a few names. I know it's confidential, but anything in the public domain, any examples which you can share, success stories by banks in this field.
Well, that's surprisingly enough, this is a question that I often get. And as much as I would love to give concrete names and details, I mean, it is a policy of ours to be, effectively to be confidential. So unfortunately, Pratik, I cannot give any names. I do want to say that it is something that we've seen a major uptick in recent years. Litigation funding is growing rapidly, also in areas where it was not used before. So not just in the Americas and in Europe. We are doing a lot of work in Northern Africa, in Sub-Saharan Africa, in the Middle East, in South Asia, basically anywhere, including a lot of banks. But unfortunately, we always, just like you as a lawyer, sort of value confidentiality. So I'm always incredibly careful not to give any.
My job was to try, and I did. And I think your job was to not answer, and you did that. So I think we've both done our jobs, and I think the panel has done theirs. And with this, we come to the end of the session. Unless there are any questions from the audience, I would like to hand it over to the organizers to take it forward.